This presentation provides basic guidelines when preparing for and conducting interviews that promote fair and consistent participation in the interview process in accordance with federal and state laws. Before beginning this training, here is some background on why you are taking this training. As federal contractors, universities must periodically provide training to supervisors on how to avoid unlawful discrimination when making employment decisions. This training is available as a refresher to the comprehensive online training titled EEO Hiring Process Guide for Managers and Search Committees that all hiring managers and employees who serve on search committees or interview panels must complete every 3 years. It's designed to provide you with the basic information needed to conduct an interview. Estimated time to complete the training is 20 minutes. Now you are ready to start the navigation process to begin the training. At the end of this module, you should be able to identify the key components of an interview. Be aware of what are considered discriminatory questions or topics. Learn how to avoid treating applicants unfavorably based on their protected class. Understand how an interview question or topic can be considered discriminatory to avoid situations that elicit protected information. Learn how to ask a behavioral-based interview question to uncover the extent to which a candidate possesses key characteristics and competencies essential for effective job performance.
There are several key components of the interview process. First, before the interview, you will need to prepare a list of job-related interview questions that reflect the requirements listed in the job posting. Interview questions should focus only on understanding the applicant's qualifications for the position and desired work-related characteristics. Asking questions not directly related to an applicant's ability to do the job could be considered discriminatory by the applicant and subjects the university to liability. It's important to ask the same predetermined questions to each applicant. It is okay to paraphrase a question or ask a candidate to expand on their response. The university system records retention and disposition schedule requires all notes from interviews and reference checks be retained on all candidates for 3 years. Your HR contact should be the record keeper of these. Specifically, the HR contact retains the application materials for all applicants and all documentation related to the search, including correspondence, resumes, applications, forms, interview notes, search committee charge and roster, policies, and reports. The remaining components of the interview process. The university system records retention and disposition schedule requires all notes from interviews and reference checks be retained on all candidates for 3 years. Your HR contact should be the record keeper of these. Specifically, the HR contact retains the application materials for all applicants and all documentation related to the search, including correspondence, resumes, applications, forms, interview notes, search committee charge and roster, policies, and reports. You should not use selection criteria that disproportionately exclude certain racial groups. Criteria must be valid predictors of successful job performance and meet the employer's business needs. Any workplace sample or test that a candidate is asked to complete should be vetted through the university's EO office. A critical component is to objectively document why the candidate selected is most qualified, as compared to others considered for the position. Base your justification on the relevant education, experience, and skills and competencies of the selected candidate. Describing someone's personality is not a competency. If strong verbal communication skills are a required competency, focus on the candidate's ability to effectively communicate concise, clear responses to the interview panel when responding to questions.
There are many laws that govern what we cannot ask during an interview. You should avoid inquiries which directly or indirectly reveal certain characteristics of the applicant that are protected under the following laws. Inquiries into the following protected characteristics could be construed as evidence of discrimination: age, religion, national origin, race, color, sex, disability, pregnancy, genetic information, veteran status, or military status. Next, we'll touch on the laws that provide protections to the applicant. The Age Discrimination in Employment Act prohibits age discrimination against people age 40 or over. Therefore, any age-based question should be avoided. It is important to understand that disparate impact can occur even if an employment policy or practice applies to everyone, regardless of age, if it has an adverse impact on employees or applicants age 40 or over and is not based on a reasonable factor other than age. Questions related to age or that can result in determining a candidate's age should be avoided. For example, a well-meaning search committee member trying to set a candidate at ease may notice that they went to the same university and ask when the candidate graduated. You may ask, why is this an inappropriate question? Because most people graduate from high school or college around specific ages, these questions should not be asked during interviews. When a candidate is considered a finalist, this information can be gathered to verify education credentials. Human Resources would be the responsible party to verify credentials of applicants.
Title VII of the Civil Rights Act of 1964 prohibits workplace discrimination based on affiliation with a particular religious or ethnic group, physical or cultural traits and clothing, perception or belief that a person is a member of a particular racial, national origin, or religious group, and association with a person or organization of a particular religion or ethnicity. For instance, it is illegal to discriminate because of physical, cultural, or linguistic characteristics, such as accent or dress associated with a particular religion, ethnicity, or country of origin. Further, Title VII requires an employer to reasonably accommodate the religious practices of an employee or prospective employee unless it would create an undue hardship for the employer. Examples of discrimination based on Title VII include denying a woman wearing a hijab, a body covering and or headscarf worn by some Muslims, employment, or not hiring a man with a dark complexion and an accent believed to be Arab is prohibited under Title VII.
Religious discrimination involves treating an applicant or employee unfavorably because of their religious beliefs. Title VII protects those who belong to traditional, organized religions, such as Buddhism, Christianity, Hinduism, Islam, and Judaism. Having sincerely held religious, ethical, or moral beliefs, are married to or associated with an individual of a particular religion. Title VII prohibits workplace or job segregation based on religion. Employers cannot segregate workers based on religion because of perceived or actual customer preference, such as assigning an employee who wears religious garb or religious grooming practices to a non-customer contact position because of actual or feared customer preference. Discussing a candidate's religion during an interview is viewed as problematic under federal law, since in most cases it is generally not job-related. Such questions are a violation of Title VII unless religion is a bona fide occupational qualification. Instead, redirect the discussion back to the questions planned for the interview.
Another protected group that falls under Title VII of the Civil Rights Act is national origin. National origin discrimination involves treating applicants or employees unfavorably because they are from a particular country or part of the world, because of ethnicity or accent, or because they appear to be of a certain ethnic background. It also protects those who are married to or associated with a person of a certain national origin. Discrimination can occur when the victim and the person who inflicted the discrimination are the same national origin. It is illegal to use an employment policy or practice that applies to everyone regardless of national origin if it has a negative impact on people of a certain national origin and is not job-related or necessary to the operation of the business. Questions about national origin could be illegal. Asking if the applicant is fluent in Spanish is not illegal. Asking if the applicant is a native Spanish speaker could be illegal. The Immigration Reform and Control Act of 1986, IRCA, also affords protections based on national origin. The act makes it illegal for an employer to discriminate with respect to hiring, firing, or recruitment or referral for a fee based upon an individual's citizenship or immigration status. This act prohibits employers from hiring only U.S. citizens or lawful permanent residents unless required to do so by law, regulation, or government contract. Citizenship requirements may violate Title VII if they have the purpose or effect of discriminating on the basis of national origin. An acceptable question would be, are you authorized to work in the U.S.? An unacceptable question would be, are you a U.S. citizen?
Title VII of the Civil Rights Act also protects individuals based on race and color. Race discrimination involves treating an applicant or employee unfavorably because they are of a certain race or because of personal characteristics associated with race, such as hair texture, skin color, or certain facial features. Color discrimination involves treating someone unfavorably because of skin color complexion. Race color discrimination also can involve treating someone unfavorably because the person is married to or associated with a person of a certain race or color. Discrimination can occur when a victim and the person who inflicted the discrimination are the same race or color. As for previously mentioned protected classes, disparate impact can occur when an employment policy or practice that applies to everyone, regardless of race or color, has a negative impact on the employment of people of a particular race or color and is not job-related and necessary to the operation of the business. There are no acceptable questions on race or color during an interview. Title VII also protects employees from being discriminated against based on sex. Sex discrimination involves treating an applicant or employee unfavorably because of their sex. It is a violation of Title VII to discriminate against a person because of sex, sexual orientation, or gender identity, including transgender status. Disparate impact can occur when an employment policy or practice that applies to everyone, regardless of sex, has a negative impact on the employment of people of a certain sex and is not job-related or necessary to the operation of the business. Questions about children often are used to discriminate against women. Information about dependents needed for tax or Social Security purposes can be obtained after the applicant is hired. There are no acceptable questions about sex that can be asked by a hiring manager, search committee, or interview panel. Examples of unacceptable questions to avoid include, where does your spouse work? Or, how many children do you have? Even if these questions are asked to all candidates regardless of gender, they have been recognized as having a disparate impact on women.
Under the Americans with Disabilities Act, it is unlawful to make any pre-offer inquiry about an applicant's disability. Do not ask disability-related inquiries, such as whether the applicant has physical or mental disabilities, present or past physical or mental health treatment, and present or past use of medication. During the interview process, the interviewer should take special care to avoid the questions that could be considered discrimination against people with disabilities. No question should be asked about the applicant's record of disability or treatment at the pre-offer stage. If asked of all candidates, an acceptable question would be, can you meet the requirements of the unit's work hours, overtime work, and attendance policies? An example of an unacceptable question would be, will you need time off for medical treatments or for other reasons associated with your disability? Discriminating against applicants with caregiving responsibilities could result in discrimination based on sex, disability, or other characteristics protected by federal employment discrimination laws. Questions should focus only on the applicant's qualifications for the job in question. Do not ask questions about the applicant's children, any plans to start a family, pregnancy, or other caregiving-related issues during interviews. Job-related qualification standards should be developed that reflect the duties, functions, and competencies of the position, while minimizing the potential for gender stereotyping or other unlawful discrimination. Standards should be consistently applied in the employment decision process. When comparing applicants' work histories for hiring or promotional purposes, focus on work experience and accomplishments, and give the same weight to cumulative relevant experience that would be given to workers with uninterrupted service. Questions related to caregiver status may violate Title VII if used to deny or limit employment opportunities. Focus on what the job requires to phrase your questions appropriately. An unacceptable question would be, what are your childcare arrangements? An acceptable question would be, travel is an important part of the job. Do you have any restrictions on your ability to travel?
Genetic information is one of the newer protected classes. Under Title II of the Genetic Information Non-Discrimination Act of 2008, or GINA, it is illegal to discriminate against employees or applicants because of genetic information. The EEOC enforces Title II of GINA. Genetic information includes information about an individual's genetic test and the genetic test of an applicant's family members, as well as family medical history. An employer may never use genetic information to make an employment decision because genetic information is not relevant to an individual's current ability to work. An example of an unacceptable question related to genetics would be, what is your family medical history? There are no acceptable questions related to genetic information. The Uniform Services Employment and Reemployment Rights Act, or USERAA, prohibits employers from discriminating against employees or applicants for employment on the basis of their military status or military obligations. USERRA protects the reemployment rights of those who leave their civilian jobs to serve in the uniformed services. The Vietnam-era Veterans Readjustment Assistance Act, or VEVRAA, requires that businesses with a federal contract or subcontract in the amount of $100,000 or more entered into on or after December 1, 2003, take affirmative action to employ and advance qualified disabled veterans. VEVRAA requires these businesses to list their employment openings with appropriate employment service delivery systems and to give covered veterans priority in referral to such openings. It is illegal to treat an applicant or employee unfavorably in all aspects of employment because of a disability, a history of having a disability, or because the employer regards the applicant as having a disability. Acceptable questions include, what type of education, training, and work experience relevant to the job did you receive while in the military? Unacceptable questions include, what type of discharge did you receive? Have you ever been diagnosed with PTSD?
Interview questions can span multiple types of discrimination. Asking certain questions related to an applicant's work schedule could suggest religion, race, or sex discrimination. Affiliation-related questions could give rise to discrimination charges tied to race, sex, religion, or national origin. Questions about physical characteristics could limit applicants based on race, sex, or national origin. In addition, background checks could limit employment based on race or sex. To wrap up, there are several key points to remember when interviewing. Interview questions should reflect the requirements listed in the job posting. Ask the same predetermined questions to each applicant. It is okay to rephrase a question or ask a candidate to expand on their response. Objectively document why the selected candidate is the most qualified based on relevant education, experience, and competencies. Do not ask questions that directly or indirectly inquire about an individual's protected class status or that are not job-related. Avoid inquiring about a candidate's age, gender, disability, race, sexual orientation, marital status, national origin, religion, finances, military discharge, union involvement, workers' comp claims. If candidates offer protected information voluntarily, redirect the conversation away from the topics, and do not consider the information when evaluating the candidate.
What is behavioral-based interviewing? Behavioral interviewing requires candidates to respond with specific examples of past experiences rather than generalized responses. Past performance is the most accurate predictor of future performance. The framework for behavioral-based questions requires the applicant to respond by describing the situation, task, action, or result. Behavioral interviews are founded on the belief that past performance is the best predictor of future performance. Questions are designed to uncover the extent to which a candidate possesses key characteristics and competencies essential for effective job performance. Behavioral questions often begin with, "Tell me about a time when," "Describe a situation," or "Give an example of." Some areas where behavioral questions are used include communication, organization, problem solving, innovation, and diversity. At the end of this training, you will find a resource link to a UNC handout that expands on using behavioral-based interview questions.
To wrap up this training, there are several key points to remember. 1. Avoid asking interview questions that lead to discussions about or implications about a candidate's race, color, religion, national origin, age, sex, gender identity, ability status, veteran status, genetic information, or sexual orientation. Be mindful of the conversation and comments made during rides to and from the airport, lunches, evening receptions, or just walking between meeting rooms with candidates. 2. Use behavioral questions to uncover the extent to which a candidate possesses key characteristics and competencies essential for effective job performance. Behavioral questions often begin with, "Tell me about a time when," "Describe a situation," or "Give me an example of." In addition to this training video, there are 2 more training videos available. EEO Hiring Process Guide for Managers and Search Committees, a comprehensive 1.5-hour training video, and The Hiring Process, a primer for hiring managers and search committee chairs, a 20-minute video that provides a refresher on the overall process. There are also 2 written resources available on UNC General Administration's website, EEO Guidelines for Interviewing and Overview for Behavioral-Based Interviewing.